Oops. Thank you very much. Thank you very much for the invitation. We are having kind of a cut. We're going a bit back to the last panel and directly back to differentiated responsibilities and differential responsibilities and respective capabilities and some other issues on a more concrete political challenge, and that is the negotiations on COP29, which is, as you know, taking place in Baku in Azerbaijan in November. We have, this is what I'm going to do just very quickly with you, but I start. We have COP29 and the main topic for negotiation will be climate finance. I will explain that in a second. It is clear that climate finance is on top of the agenda. The presidency of the COP29 meeting highlighted that we do not know yet whatever the outcome will be. We have to see, as it is typical for a COP negotiations, and results only emerge in the last minute or even second. The background for my topic on climate finance is already the Framework Convention that has, as you might know and probably do know, a general commitment towards the developed countries of climate finance, a bit more in detail explained as facilitating and financing as appropriate, transfer access to environmental sound technology, know-how, and so on and so forth. This has been made more concrete in the Copenhagen Accord of December 2009, where the $100 billion goal that we have talked about already in the last 1.5 days has been set. And the Paris Agreement goes a step further in terms of that it, as you all know, got rid of the annex countries, and we have only a differentiation now between developing and developed countries first. And secondly, we have two essential obligations for climate finance, and that is the general obligations for all contracting parties under Article 21C of the Paris Agreement in rather broad language, but it clearly indicates, as you can see, that all contracting parties, 195, as you all know by now, have an obligation of making finance flows consistent with pathway towards low greenhouse gas emissions and climate resilient developments. That is for all countries, and more specific than for developed countries, we have the famous Article 9, which has more complete obligations that then are about to be extended and made more concrete for the period after 2025. That is to say, the goal that was set in the Copenhagen Accord. This is what we are talking about and will talk about in November in Baku, to have a new goal set at the negotiations. This has already been mentioned, and the 100 billion goal has only been reached somewhere in between here. So just recently, more or less. So we are now on track, but way too late, one could certainly say. What is needed, just in very broad terms, I come to more concrete challenges in a minute. We need, of course, nationally determined contributions, commitments countries make to reduce. We have necessity that these commitments include concrete policy and other measures. And we have, of course, the Paris target. Coming back more concrete to climate finance, what we are looking at is actually not anymore the 1 billion goal, but we are looking about something, wherever that is at least 6 times greater than the original goal. That is a lot, as you can imagine. Indeed, we are talking about 6 trillion until 2030. And that means at least 600 billion a year. Whereas, as I said, we have 100 currently, and that took a long time actually to reach. So that is a lot. Yeah? If we believe in these calculations, I don't want to question them, it's not my business. But if we take this, and there are other estimates, United Nations Conference on Trade and Development estimated even more in this regard. Whatever it is, in concrete terms, that's for others to decide. It is a lot. The challenge, so to speak, we are facing is costly, tremendously costly.
So can I just check, is that's 2030, the bottom date?
Sorry, yes, 2030. There's a there's a bit too many figures. No, sorry,
That really is.
I haven't seen that. Yeah, that's right. Yeah, absolutely. Sorry. Where are the challenges in terms of negotiation? And where are the challenges with regard to the legal framework I'm going to talk about in a minute? We have 7 main challenges: quantity, who's contributing, the time frame, covered themes, scope, quality, and transparency. And that is what is at stake and what is on the table in the negotiations. I'm not going to in detail to all of these 7 challenges, but only on 2. First, who shall contribute is one of the main discussions that has been mentioned in the previous panel already. That is the question: only developed countries, also the developing countries, among the group of the developing countries, who, under which conditions. And secondly, what is exactly, and it relates to that, this obscure relationship between Article 9 and Article 21C of the Paris Agreement. Again, 21C sets an obligation for all contracting parties, all 195 contracting parties for financial contributions, whereas Article 9 makes it specific with regard to developed countries. And that is a bit unclear with regard to the text where we are. The background, and now more on public international law for this, is of course common but differentiated responsibilities and respective capabilities. It's important to add this as it is laid down in the treaty. Therefore, not only CBDR, but the CBDR-RC. And that makes a significant difference, and I will further elaborate on that. Already the Framework Convention highlighted this famous principle, and it is then underlined and has been restated in the Paris Agreement. The principle of common but differentiated responsibilities has been referred to by, first of all, domestic courts in several climate change actions. Beginning with the famous decision of Uganda in the Dutch Supreme Court, but the Norwegian Supreme Court and other courts have referred to it. Without going into detail, I think one can make a very strong argument that the principle as such is customary international law by now, considering how widely it has been referred to and how widely it shaped treaty practice and domestic practice of states. The interesting aspect, coming also back to this morning, Rüdiger Wolfram, but also the last panel, is what the International Tribunal on the Law of the Sea did with this. And one could criticize specifically the passages in the judgment, in the advisory opinion on common but differentiated responsibilities of being too vague, and there was an opportunity maybe for the tribunal to go further and be a bit more clear. That can be criticized. On the other hand, we do now have an international court, a tribunal that made some clear statements on what the consequences of common and differentiated responsibility are. First of all, the court refers to the principle, and then secondly, it clearly indicates, you don't have to read everything. First of all, that it is essential with regard to finance, so that there is essentially an obligation of climate finance deriving out of the principle of common but differentiated responsibility. And secondly, that this is part, in a broader sense, of a just and equitable international economic order. This is language deriving from the preamble of the United Nations Convention on the Law of the Sea. Essentially, in this regard, is equity as the probably underlying principle behind all this, what we are talking about. It depends a little on your legal background, of whether you are comfortable with equity or not. Being a civil lawyer, it's a bit more complicated than coming from a common law country. But it is also in the literature accepted that equity is essential in this regard. Further statements by the International Tribunal on the principle and financial assistance, then as in legal public international law obligation in this regard with regard to climate change. So we have a solid ground, I would say, legal ground for what is discussed and for a long time and will be discussed in Baku. But we have some challenges. And the main challenge, I would say, and now I'm broadening the picture a bit to the international economic order, is this strict differentiation we have between developed and developing countries. In international law, we have a third category, the least developed countries. I leave them out because it's a different mechanism of identifying them. But essentially, we have only those two categories in a very strict sense. And as you probably all know, one is a developing country if one decides to be a developing country. It's a principle of free assignment in this regard. And we have legally, within the group of developing countries, no differentiation whatsoever. And that is causing a bit of complicated problems. First of all, you can see that already as my time is running out. I was preparing this for 20 minutes. In the relationship of Article 2 and Article 9, I cannot, where we have an overlap, and an overlap that is an indication, in my opinion, on a further necessity to differentiate also in the group of developing countries. And secondly, we have interesting developments in other areas of international law where we do take that into account and not only apply a general differentiation of developing and developed countries, but make an internal, more differentiated picture. And that is, without going into detail, the agreement on fisheries subsidies in the World Trade Organization, where appropriate and effective special and differential treatment is mentioned. That's very interesting because it's probably the first time that we do try to differentiate within this large group of developing countries with respect to appropriate and effective. So what can countries actually do beyond the old question of capabilities? I don't have time to go into that in more detail. A second aspect that shouldn't be last minute, not forgotten, is that we not only have positive obligations of climate finance in this complicated sense, as I indicated, but we have also negative obligations, in my opinion, on climate finance. And that is to say, not only financial contributions for mitigation, adaptation, and maybe loss and damage, but also an obligation not to imply measures that increase costs for climate mitigation. And I want to give you one example where we can discuss on whether this principle is violated. And this is what has been decided this morning in Brussels in a very sensitive area, and that is subsidies, anti-subsidies measures on electronic cars from China. An issue that from an economic perspective one can discuss, but preventing to come the electronic cars to on a cheap basis to come to Europe. So, and that is of course totally contrary to the zero emission target for cars of the European Union. And maybe it's contrary to the interest of the Union, which is part of the legal framework for anti-subsidies measures. The last sentence, the European Union Constitution explicitly provides in Article 21 that we take, among others, global environmental aspects into consideration while shaping our foreign policy, including foreign trade policy. If we take that, and if we take Paris and all what we have discussed the last 2 days, then the question is, in a situation like electronic cars, shouldn't we accept that we have an overreaching goal that is more important, so to speak, in a way in balancing situation than anti-subsidies measures? Thank you very much for your attention.